This is All India Radio. In the program Spotlight, now we bring you a special discussion on various facets Indian Constitution. The participants are P.D.T. Achary, former Secretary General, Lok Sabha and constitutional expert, and Pragya Deora, AIR Correspondent.
India's constitution was framed by a Constituent Assembly which was set up under the Cabinet Mission Plan 1946. This Constituent Assembly adopted the Constitution on 26 November 1949, a date which finds its mention in the preamble of our Constitution. Due to the significance of this date, the Government of India in 2015 decided to celebrate 26 November as Constitution Day every year. In order to appreciate the Constitution, it is important that we understand the context in which it was framed. Could you explain to us the context, both domestically and internationally, in which the Constituent Assembly was framing this Constitution, and what were the challenges they had to face, and how did they overcome it?
See, the Constituent Assembly was elected in 1946. But before that, as early as in 1935, the All India Congress Committee had made this demand that a Constituent Assembly should be constituted so that free India's constitution could be framed. But the British government did not do anything in the beginning, but towards the end of the World War II, the British government woke up and suddenly they thought about the Constituent Assembly and then framing a constitution, and they wanted to give dominion status to India, which was not acceptable. And then finally, the Constituent Assembly was agreed upon and the Constituent Assembly elections were held. One very interesting thing about the election to the Constituent Assembly is that the elections were conducted on the basis of communal representation, not on adult franchise. Communal representation means the entire population was divided into three: Muslims, Sikhs, and the general. And certain seats were allotted to each of these groups. So elections were held. The Congress party got the maximum number of seats, and then the Muslim League under Jinnah secured majority of the seats. These were those areas which were Muslim dominated. But the Muslim segment of the Constituent Assembly did not join the deliberations. There were altogether 399 members in the beginning. But then, in the meantime, a lot of political developments took place in India. The Muslim League demanded partition. They wanted to have a separate nation. And finally, that came about in 1947. After that, the Constituent Assembly that met for India, that was reduced in size. We had about 299 members. Now, in this Constituent Assembly, they set up many committees. Most important committee was the drafting committee. The drafting committee was headed by Dr. B.R. Ambedkar. Actually, he did monumental work in the framing of the drafting of the Constitution. The entire drafting work was done by drafting committee. But the preamble was prepared or drafted on the basis of the objectives resolution which was moved by Pandit Jawaharlal Nehru in the first meeting of the Constituent Assembly. And in that resolution, the entire concept of a free India became the basis of the preamble of the Constitution. For example, the liberty, equality and fraternity, justice, social, economic and political, and freedom of expression, freedom of speech and freedom of conscience and freedom of religion. These were the things which were there in the objectives resolution. And the same thing find a place in the preamble of the Constitution. Now, the Constituent Assembly took about 3 years to complete the job. And finally, on 26 November 1949, the whole exercise was completed and the Constituent Assembly adopted the Constitution. But certain provisions were brought into force, but the entire Constitution was not brought into force on that day. Then it was brought into force after 2 months, that is on 26 January 1950. That was declared as the Republic Day, and the Constitution came into force on that day.
The federal structure is an important aspect of the Constitution. Can you tell us how this has evolved over the years and where do we stand on this front today?
In the 1935 Government of India Act, the whole concept of federal structure was incorporated. 1935 Government of India Act was meant to give India greater autonomy and give the legislature more powers of the autonomy and to allow the governments to be elected from the British provinces. So, in a way, 1935 Government of India Act was a watershed. And 1935 Government of India Act contained the provisions of a federal structure, which means the legislative power was divided between the center and the states. And entire legislative power was based on three lists, that is the union list, the state list, and the concurrent list. So the entire structure was there in the 1935 Government of India Act. The same structure was adopted by the Indian Constitution without much of a change. Of course, there were some modifications. So we have adopted the federal structure. But Indian Federation is not a classical federation, as we find in the United States of America. The difference is, in the United States, it is the states which federated. States came into existence first and they federated to a union. But here it is not so. The states did not federate. The federation was created and legislative power was divided between the states and the center. But the center has overriding powers. For example, in our case, there is an emergency provision and there are provisions under which the central government can give directions to the states, and if that direction is not listened to or adhered to, then the center can even invoke Article 356 and take over the administration. These provisions actually militate against federalism. But in Indian Constitution, you have these provisions, and that is why it is often said that Indian Federation is not a classic case of federation. It is a federation in a loose sense, and it has many unitary features. Unitary features mean the central government has overriding control over the states. Now, in respect of the legislative power also, there is a concurrent list. Concurrent list means all those, in fact, laws can be made on all those items. Laws can be made by both the center and the states. If a state makes a law and which is repugnant to a law made by the center on the same subject, then only the central law will prevail and the state law will go. And also, even if there is no repugnancy, the central government can override a law which is made under the concurrent list. So there are so many other provisions which make it a weak federation. Of course, it can be called a federation basically because the legislative power is divided between the center and the states. So that is a basic feature of federation, division of legislative power. But beyond that, the overriding powers rest with the central government, and also central government has the residuary powers. The parliament has residuary powers, whereas in American Federation, the residuary powers are with the states, but here the residuary powers are with the central government. That is why there are very basic differences between the American Federation and the Indian Federation.
Since we're talking about the federal structure, how do you view the 101st Constitutional Amendment Act with regards to the Goods and Services Tax?
Well, you see, Goods and Services, that is the GST. GST is a provision where the states as well as the center come together, and there are discussions on various taxation measures. So it is some kind of a cooperative effort. There, of course, the central government has greater weightage, but that is how it is. In consonance with the general approach of the Constitution with regard to the center-state relations. But it is a cooperative effort. Both the center and the states come together, sit together. There is a statutory forum where they discuss the details of the taxation measures and they decide. So that is not in conflict with the federation.
Another aspect that our constitution deals with is democracy, and free and fair elections are absolutely essential for a thriving democracy. In the current setup, whose responsibility is it with regard to electoral reforms, and how has India performed on this front?
The elections have been held in this country for a very long time. The first elections were held in 1952. The elections are conducted by the Election Commission, which is the constitutional body. It's an autonomous body. It has autonomous powers to conduct elections in a free and fair manner. That is the mandate of the Constitution, to conduct elections in a free and fair manner. The Election Commission has done a very good job in conducting elections, and they have issued directions. Those directions have also the force of law. So the Election Commission is all powerful so far as the conduct of the elections are concerned. Now, so far as electoral reforms are concerned, well, electoral reforms basically done by Parliament, because we have a law which deals with all aspects of election. That is the Representation of People Act 1950 and 1951. Representation of People Act 1950 deals with the preparation of electoral rolls and the related matters, whereas the Representation of People Act 1951 deals with all aspects of the elections. Elections to the Parliament, elections to the state assemblies, elections to the office of the President and the Vice President. So all these are done by the Election Commission. But Representation of People Act 1951 deals with elections to the Parliament and also elections to the state assemblies and councils, wherever they are. That is a structure that we have in the Constitution. If the question is about the electoral reforms are carried out by Parliament by amending the law. In fact, electoral reforms, there are various suggestions come at different times from various quarters. Election Commission itself makes suggestions about electoral reforms.
So in your opinion, how has India performed on this front so far?
Electoral reforms have been done from time to time, but it is not that electoral reforms are done frequently. That is not required because we have a very stable kind of law which deals with all aspects of the elections. But periodically, amendments have been made in this law. I think this law has stood the test of time. Well, all these elections, all these years, the elections have been held on the basis of this law. There is always a scope for carrying out reforms in the electoral law. A responsive government in a democracy is certainly bound to listen to opinions which are coming from the civil society and from the constitutional bodies like the Election Commission and so on.
One more important aspect is the relationship between the judiciary, executive and the legislature. What has the Constitution envisaged in this regard?
There is a separation of powers in the Constitution. We have the executive, which is responsible to the legislature, that is Parliament. Here and in the states, it is the Assembly. So, executive is a creature of the legislature. The executive means the Council of Ministers. That is the political executive. That comes from the legislature itself. Now, in a democratic setup, the executive is responsible to the legislature. That means they are accountable to the legislature. Therefore, there is a close relationship between legislature and the executive. But so far as the judiciary is concerned, judiciary has an independent role. They have to see whether the laws that are made by Parliament and the state legislatures are in accordance with the Constitution. If it is not in accordance with the Constitution, if it violates the Constitution, then that will be struck down by the judiciary. So judiciary has a responsibility to protect the Constitution. And protect the Constitution means the judiciary has a right to protect the rights of the people which are enshrined in the Constitution and do justice to the people. So doing justice is the primary duty of judiciary. And that duty is performed by judiciary without any fear of favor. So judiciary is independent. They cannot be influenced or coerced. So they have to take independent decisions. So that is the kind of relationship. So the power of the state's power has been divided between the legislature, the executive, and the judiciary. Judiciary is independent. Judiciary looks into the acts of the legislature and also the executive and see whether these acts are in conformity with the Constitution. And if it is not, then judiciary will strike down those acts as unconstitutional.
As a concluding thought, the Constitution of India has stood the test of time. Could you discuss as to what have been the reasons for this?
Well, the Constitution as a fundamental law of the land has stood the test of time. Test of time in the sense that this Constitution is flexible. It is flexible means it can be amended through a comparatively easy process. That is, 2/3 of the members present and voting in the House, each House, can amend any part of the Constitution. And therefore, that flexibility is available in the Constitution. And that is what actually made it meet the changing situations and the challenges. Because new challenges have come over these years, and every time the Constitution was amended to meet the changing needs. And yet, the spirit of the Constitution remains the same. The basic approach and the basic philosophy of the Constitution has remained intact. So that shows the resilience of the Constitution.
Thank you very much, sir.
Thank you.
You were listening to a special discussion on various facets Indian Constitution. The participants were PDT Achary, former Secretary General, Lok Sabha and Constitutional Expert, and Pragya Deora, AIR Correspondent. This program was produced and presented by the News Services Division of All India Radio. You can listen to it on a mobile app, News on AIR. This program is also available on our YouTube channel, News on AIR Official. You may email your opinion about this program at airnsdtalks@gmail.com.